When most people think about a patent, they are thinking about a utility patent. Everything we hear, movies, the press, you name it, associates patents with great technological inventions. The Wright brothers and the airplane immediately jump to mind, with automobiles and intermittent wipers being a distant second place for me. And while utility patents often offer the broadest protection for a business, there is another type of patent that works extremely well in many, many cases. In fact, for many inventions, a design patent can protect your invention better than a utility patent and make you and your business a lot of money. Let's get into it. Utility patents are generally considered to be the gold standard for intellectual property protection, and utility patents have numerous advantages, with the main one being that a skilled attorney can draft claims using written language that can encompass the innovation while still providing very broad protection. Claims for design patents, on the other hand, are drawings. While this is not a class for how to draft a design patent, I want to discuss some of the advantages that design patents have over utility patents, especially for small businesses. To start, let's provide a quick overview of what is a design patent, which is a patent that protects aesthetic inventions. Aesthetic means the appearance, in this case, the appearance of an article of manufacture. The claim of a design patent are a number of drawings that show the claimed features of the invention in solid lines. A design patent can relate to the configuration or shape of a product or to surface ornamentation that is applied to the product. This is what a design patent looks like. And these drawings are the claim. Importantly, there can only be one claim. Other countries have something similar to a design patent, and they typically call it an industrial design. Now, on to the advantages. First, a design patent is a lot less expensive to obtain than a utility patent. A simple design patent with 4 sheets of drawings can be drafted and filed by a skilled attorney for about $2,800. A simple non-infringement utility patent will typically cost more than $6,000 to file. I will put a link to our website that has ballpark pricing for patents on the screen now. Feel free to pause and copy it down if you want to look further. If you're on YouTube, the link is also in the description below. Second, a design patent will usually issue a lot faster than a utility patent. Most utility patents take 2 to 3 years to issue, and some can take much longer. Most design patents will issue in about a year, with some issuing faster, and that is without paying the fees for Track 1 examination. Third, and this is a big one, a design patent allows the design patent holder to obtain an accounting of profits, while a utility patent does not. For a utility patent, most plaintiffs will be forced to argue for what is called a reasonable royalty, which might be a few percent or even less of the cost of the infringing part of the accused product. In some cases, a utility patent holder can argue for lost profits, meaning the profits that they would have made if they did not have to compete with the infringer. On the other hand, an accounting of profits is an equitable remedy which allows the plaintiff to obtain all of the profits the defendant made from an infringing product. This is a huge difference from utility patents. This means, in effect, that a much smaller plaintiff can still get all the profits from a much larger infringer. The reason that some patent verdicts reach into the billions is because they were based on design patents. The infamous verdict by Apple against Samsung was a design patent win. Back to advantages. The fourth advantage, which is really an extension number 3. Because a design patent holder can obtain an accounting of profits, when a design patent is pursued, the plaintiff can obtain an asset freeze. An asset freeze means that the defendant's accounts are frozen. They cannot take money out. And further, the plaintiff can, in many cases, obtain that asset freeze ex parte, meaning that the defendant will not be able to contest the asset freeze and instead will have to deal with it in some other way. Due to certain legal technicalities, an asset freeze is only available in a limited number of cases, and design patent infringement is one of them. The asset freeze is absolutely enormous. It is why you will never see a mass lawsuit against online sellers based on a utility patent. When an asset freeze is applied, it freezes all of the assets that a seller has in a particular account. All of it is at risk unless they settle. We have seen cases where a seller will have $1 million or more frozen for weeks until they settle the case. So the pressure to settle is huge. And these online lawsuits against mostly Chinese counterfeiters are big business. Hundreds of millions of dollars change hands every year. And that brings us to the heart of the matter. I am always looking for ways to help my clients achieve a higher return on their investment in intellectual property. And this is a big one. If you want to defend your product against Chinese counterfeiters, and you want an attorney to take your case on a contingent fee, a design patent is actually better than a utility patent, at least in this one way. So those are a few reasons why a design patent can provide a lot of advantages to a small business. That's not to say that utility patents are bad. They are not. In most cases, they are actually better than a design patent. And if you would like a video about that, let me know. And if you're interested in help with intellectual property, including filing for or enforcing a design patent, a utility patent, or another type of IP, feel free to reach out. All the attorneys at my firm are intellectual property attorneys, and we are always excited to help our clients protect and make money off of their IP. And last but not least, have a great day.